Hi everyone, thank you so much for joining our webinar today, Independent Contractor or Employee, Avoiding the Game of Guess Who. My name's Amanda and I'll be your moderator today. ERISA attorney Larry Gugine is our presenter. Larry has packed a lot of information into these slides, so if you miss something, don't worry. I'll be emailing you a recording and the slides after the webinar concludes. I'll be keeping the webinar muted to avoid any background noise. Larry will pause periodically for questions, so just type your question in the box below and I'll read it aloud for you. Our next webinar will be on April 18th at 1 p.m. Central, and we'll be covering controlled group attributions. For now, Larry, take it away.
Thank you very much. The reason why I'm doing this seminar, I've been noticing over the past 3 or 4 years, more and more employers, when they hire someone, are now hiring individuals as independent contractors versus employees. And all the governmental agencies, especially the IRS and DOL, have noticed this. And I've noticed an uptick in employment tax audits. And what triggers them, especially if you have an employer that issues a lot of 1099s for people who work for the employer, that's going to trigger questions from the DOL and IRS. Now, the purpose behind this seminar is to talk about types of employees, the consequences of indicating when an individual is an employee, and thirdly, what are the consequences if you get it wrong? That's the purpose behind the seminar. So I'll be talking about contingent employees, temporary employees, what are the factors involved, and there's a lot of litigation in regard to this. So I'll be giving an overview of the rules. I'll talk about the categories of contingent workers. More and more people are hiring temporary employees, leased employees, talking about those kinds of individuals. Contingent worker versus employee analysis. And then what happens if you miscategorize or misclassify an employee? These are issues and areas of potential liability. I'll be talking about wage and hour problems, employment tax, employee benefits, and workers' comp. Also, I'll be talking about other considerations such as intellectual property concerns, discrimination, harassment issues, tort liability for acts of contractors, privacy concerns, immigration compliance, international issues, and then things you may want to think about, especially if you're going to hire somebody as an employee or as an independent contractor. What should be in their contract for services? What are things that you should protect yourself when you have someone who is working for you in any capacity? That's what I'll be talking about. Now, there's types of categories of contingent workers. There's purely independent contractors. These are people that you give a 1099 to. They are, again, treated as not employees. They're treated as being sole self-employed. You have no responsibility to them. Interns, generally, there are both paid and unpaid interns. Many times unpaid interns are not considered to be employees. You got to be real careful in that regard to that. And then temporary employees. Temporary employees are individuals who can be hired through an agency or, again, directly from the employer. And these are individuals that work for a limited period of time. What I've been noticing recently is that these have been very popular, especially ever since the Affordable Care Act was passed, to get around, some employers are doing this to get around the 50 or more employees. Others want to limit their liability and are going to PEOs, and there's a joint employment or co-employment situation. So a lot of this is somewhat murky. I've run into also situations where an employer will have a temporary employee. When I ask how long they worked there, it's not unusual to get 2 to 3 years, which is very troublesome, and I think the IRS and DOL will look at that. And also because of recent developments in technology, more and more employers are hiring remote workers. These could be independent contractors, temporary employees. These are people that are remote and for various reasons work for the employer. So I'll be talking about each of these contingent workers. So while the definitions may vary, the term generally employed as a catch-all phrase for workers employed through non-traditional, intentionally impermanent working arrangements such as independent contractors, leased employees, consultants, on-call workers, part-time workers, and temporary workers. And again, it's up to you in that situation to differentiate between those that are actually employees who you have responsibility for and situations where you're going to treat them as independent contractors. And again, the problem with this, and I'll be talking about this, is the fact that it's the facts and circumstance. You have to look at the relationship and you have to find out how much control the employer has over that individual, how much time that employee works for the employer. These are all factors going into determining whether you treat them as an independent contractor and give them a 1099 no responsibility, or an employee where you have to basically give them a W-2. Now, what is a contingent worker? Continued the Equal Employment Opportunity Commission, workers who are outside of employment's core workforce, such as those jobs that are structured to last only limited time, are sporadic or different in any way from norm, full-time, long-term employment. And this is happening over probably the last 10 or 15 years, and employers have dealt with it various ways. From the Department of Labor, Bureau of Statistics, those who do not have an implicit or explicit contract for ongoing employment. These are contingent workers, persons who do not expect to continue in their jobs for personal reasons, such as retirement, returning to school, are not considered contingent workers, provided that they have an option of continuing the job and were it not for these reasons. So again, employers are taking advantage of these situations. Sometimes they're treating them as employees, other times as independent contractors. Now, independent contractors, these are self-employed individuals who are contracted to perform specific assignments or tasks either for finite or until completion of assignment, and are compensated on a contractor fee basis. Most of your professionals are an attorney, an accountant, they're independent contractors, they're not your employees. So if a worker is an independent contractor, the worker must pay the full amount of his FICA and Medicare and pay their own income taxes directly. So again, like most of your professions you hire, you have no responsibility, no workers' comp, no tax liability in that situation. And traditionally, independent contractors may work for a number of different employers. So again, you don't control when they work and how they work. And one thing, it's also very interesting, I've noticed more and more, some employers are actually offering benefits to independent contractors. There's a misnomer in the term 1099 employees. They're not employees. They're independent contractors, not employees. And I'm concerned about this because many insurance companies look the other way and let an employer cover independent contractors in their benefit programs, especially their medical. The issue and problem with that is you're one step away from that individual when you cover them and being considered your employee. That's the first concern I have. The second concern I have is basically when you have unrelated employers participating in your plan, basically what you've created is a multiple employer welfare arrangement, which is a MIWA. And a MIWA is, again, our special rules. In the future, I'll probably be having a seminar on this, but it complicates the administration of your plan. There's special filing requirements, there's state rules. For example, in the state of Illinois, you can't have a self-insured MIWA. So if you start covering independent contractors in your health plan, you could be probably having all kinds of issues and problems. And in the issue and problem, especially if you're an employer with offices in various states, MIWAs are regulated state by state. So one state has one set of rules and another state has another set of rules. So again, these individuals, independent contractors, even though some people call them 1099 employees, they're not your employees. You have no responsibility for them. They're not your agent. You don't control when they work and how they work. And that's the reason, because of that, they pay their own FICA and FUTA and their own income taxes. And again, more and more, I mean, I've noticed over the last, like I said, 3 or 4 years, more and more employers are turning to independent contractors, especially for short-term projects. Now, for in the definition of employees, an individual who performs services for you, who is subject to your control, and what as to what will be done and how it will be done. So again, here, the major factor in that definition is the control that the employer has over that individual. So they control when they work, how they work, and how it's done. And independent contractor contrasts that with the fact that an independent contractor is one who is retained to perform a certain work, or who controls the manner and means to which the work is accomplished. So if you hire an accountant or attorney, yes, he or she may tell you when that work is to be completed, but again, you have no control how that work is done and when it's done, unless you've put it in an agreement when the project is done, but it's on a project-by-project basis. So 6 criteria test on, especially for unpaid interns. The internship, even if it includes actual operation of facilities of the company, is similar to training in an educational environment. The intern experience is for the benefit of the intern. The intern does not displace regular employees, but works under close supervision of the existing staff. The company that provides the training derives no immediate advantage from the activities of the intern, and on occasion, its operations may actually be impeded by the presence of an intern. The intern is not necessarily entitled to a job at the conclusion of the internship, and the company and the intern understand the internship is not entitled to wages for the time spent in the internship. This is becoming under more and more scrutiny. There's a movement afoot to kind of end unpaid interns, and you have to be very careful in structuring this, and it should be only for a limited period of time over the summer and on vacations. Employers have to be very careful in regard to this. Temporary employees, and this term could mean all kinds of things for different employees, for different employers. But like I said, it can be defined several ways. Persons who are hired, trained, and paid by a temporary help firm, which assigns employees to work in a client offices and other places. So it can be, for example, hired through a temp agency. You have a specific need for a particular period of time. For 2 or 3 months, you have a project that needs to get done, so you hire someone as additional staff, and you hire it through, and one way to do it, through a temp agency. So they're the employee of the temp agency. All right, so, and again, I've seen an uptick in this, especially under ACA, when if an employer is approaching 50 employees and they don't want to go over 50, they may hire 2 or 3 or 4 individuals through a temp agency to keep them below the definition of an applicable large employer to avoid ACA. That's been very popular. Or it could be persons hired directly by the client firm with an understanding that their jobs will last a relatively short period of time. And it could include, and this is not recommended, workers who are employed indefinitely. Now, that's a problem. And some, especially if you don't hire them as employees, that's a problem. Many times, companies try not to give them benefits. They could be treated as independent contractor or employees, but when I warn employers about, if you have temporary employees, either through a temp agency or hired directly, they should not work for you for longer than 6 months, because after 6 months, especially if you hire them as an independent contractor, they're treated more and more like an employee, and the possibility of them being treated as an employer by other employees and by the employer increases as time goes on. Remote workers. Is a remote worker actually an employee? It depends. How the arrangement is structured when when a remote worker starts working. If an employee, special considerations include control of workspace or tools, worker comp considerations, exempt versus non-exempt issues, recording time, overtime, meals, and rest breaks. So again, in this situation, because of the explosion of technology, more and more employees are hired as employees and are working outside the office. So if a remote worker is a contingent worker, same analysis above, there's co-employment risk, especially if you hire them through an agency. And special considerations in terms of deferring to actual employer to manage time and productivity given remote status. And again, that's important here. How much control does the employer exercise over that remote worker? If they're only working for the employer, not working for anybody else, the employer controls how and when they get projects. That's a consideration in considering that person to be an employee. So to evaluate employment status, courts commonly refer to one of 3 tests. So let's stop right here. Amanda, do we have any questions so far?
We do. First of all, is there a way you can make this full screen, your PowerPoint?
Oh, I'm sorry. I'm sorry. I was so used to, sorry about that. There you go. Sorry about that. Should have spoken up sooner.
Sorry about that. Our question wanted to know if you could address the trucking industry. Independent contractors and owner-operators hired by motor carriers. They own or lease their trucks and control their own hours.
Well, in that situation, I think you have to, and I'm going to be addressing this in the next few minutes. It all depends how much control that trucking company exercises over that trucker. If they tell them when and how and what routes to take, they control everything about their relationship. I think it becomes close to being an employer-employer relationship. Mm-hmm. So you have to be very careful. But that's the next area that I'll be covering.
Got it. And that was the only question we have typed right now.
Okay. Okay, let's look at the meat and potatoes of this contingent worker, which means someone who's not an employee versus an employee. So to evaluate employment status, courts commonly refer to one of 3 tests: a common law agency test, a right to control, economic realities test, and a hybrid test. So these are commonly used by all the government agencies to determine whether an individual is or is not an employee. So under the common law right to control test, in this situation, involves a multi-faceted analysis, and the IRS has about 20 factors involved that examines the totality of the relationship. And in this situation, basically what the courts really rely on is the extent of the actual supervision, the control exercised by the employer over the means and manner of the worker's performance. So in the trucker situation, if the trucking company controls when they work, how they work, and suppose the trucking company, the worker only worked for that one trucking company, I think in that situation, under the common law agency, that individual will be treated as an employee. So again, control is the most important thing. How much control does that employer have over the means of doing the work and how that work is done, I think is extremely important to consider. Next, under the economic realities test, it focuses on whether the alleged employee, as a matter of economic reality, is economically dependent upon the business in which he or she renders his or her services. In layman's language, what that means is the fact that if that individual is only working for that one employer, the possibility of that individual being treated as an employee is greater. But if you have an individual that works 1 or 2 days a week for this employer, another 2 or 3 days work for another employer, and has a number of different employers that individual works for, then the possibility of that employee becoming or being treated as a particular employee of any one entity is going to be very slim. So the economic realities is broader and more inclusive than the common law agency test. So again, if individuals that just work for you, the possibility is that they're going to be treated as employees. So the hybrid test seeks to combine the common law agency test with the economic realities test. It focuses on the hiring party's right to control the means and manner of the worker's performance. It looks to the economic realities of the working relationship. So in the trucking situation, I think what we're looking at is the individual trucker has to meet certain requirements that the trucking company has to perform their duties. They have to adhere to those rules. The possibility of that trucker being an employee of that trucking company is probably much greater. And again, this is more inclusive of the traditional common law agency. So the common factors and the independent contractor tests are, again, the most important is, and no one factor, I think, is dominant over any other. They look in the totality of the situation. The right to control. Does the employer tell you when to work, how they work? The right to terminate at will. Now, again, in most employment situations, the employer reserves that right to, so that's not an important factor. The length of a relationship. The longer the relationship is with that employer, the more possibility the fact of you're going to be treated as an employee and you're going to be looked at as an employee. Distinct occupation of the or business. Are you a laborer? Are you an accountant? What are you? And I think if it takes more skill in that situation, you're going to be more as an employee, including the level of skill required. The method of payment. Are you paid every 2 weeks, just like an employee? I mean, do you submit a bill for your services, or are you paid every, a matter of course, you don't submit a bill, you're just paid automatically? Do you have an opportunity for profit or loss, or you just get a paycheck every 2 weeks? Does the employer provide tools, equipment, and place to work? And if the employer does, that probably the likelihood that you're going to be considered to be an employee, especially if you go to one place or their locations to do your work. And whether the work is an integral part of the company's regular business. I think one of the tests is that are you doing work that the normal employee would be doing? And if you're doing it for a particular length of time, longer period probably than 6 months, that's why when you hire a temp, I always, as I indicated before, you always have to warn the employer, only keep temporary employees for 6 months, because after that they're going to be more or less considered to be employee. And what are the parties' intent? I think if you have a formal consulting agreement or working agreement indicating what the relationship is, and you spell out exactly certain just basic rules of the engagement of this particular project, the possibility of that being seen as an employment relationship is probably less. Now, in this situation, the enforcement is Also potentially red flags in the situations, the business can terminate the worker at will. The business monitors the worker's performance, as opposed to, especially if you're an independent contractor, it could work both ways. If you're an independent contractor, you have a contract to do particular duties, you're not going to be, again, terminated until that project is over. If the business monitors the worker's performance, that's a general indication that individual is going to be an employee. The worker must follow the business policies and procedures. The business provides training to the worker. That's an indication that you're going to be considered to be an employee. The business provides tools or for a place of business. The relationship is permanent or indefinite. There's no end to the project. It just goes on and on and on. The worker is paid on an hourly or salary basis instead of on a project basis, which is more in a situation where if you're paid on a project basis, you're going to be seen as an independent contractor. The business has employees who do the same work you do. Now, again, the only exception to that, I think, is especially if you're hiring temporary employees for particular projects, and if it's short term, then I think you're likelihood that you're going to be seen as an employee. A few months, 3 months, 4 months, up to 6 months possible. But any longer than that, if you're doing the same job as all the other employees, I think both the IRS and DOL are going to see you as being an actual employee. And the worker does not exercise any business skills, judgment, or incentive. In that situation, that would be seen as being an employee. So what are the agencies that will enforce this? And again, these are agencies that will actually will conduct audits, especially if an employee complains or they see a filing of a lot of 1099s. We're looking at the Department of Labor on the federal and state side, Internal Revenue Service, state equivalents, and state agencies administering unemployment insurance. Because in this situation, they're looking to see if employers are skirting some of the requirements. On the IRS side, there's a penalty of $50 for each W-2 not filed, penalties of 1.5% of wages plus 40% of FICA taxes not withheld, and 100% of matching FICA taxes the employer should have paid, failure to pay a tax of 0.5% of unpaid tax liability per month, and 25% of total tax liability. For an intentional misrepresentation, there's a penalty of 20% of all wages and 100% of FICA taxes, with criminal penalties of $1,000 for each misclassified worker and 1 year in prison. So again, there's incentive on the various governmental agencies to look at this and to make sure that they find employers that are abusing this. Also, an individual responsible for withholding taxes could be held liable for intentional misrepresentation cases. Recent DOL settlements and judgments of $1.5 million judgment for 250 cable installers overtime that wasn't paid, $560,000 related to telemarketers, minimum wage and overtime rules, and $395,000 for construction workers overtime, $277,000 assessment for janitor workers for minimum wage and service requirements. So again, under Obama administration, the government was actively pursuing this. Let's see what the Trump administration does in this situation. But again, this is one area, and only because under the ACA, more and more employers were hiring temporary contingent workers to fill in gaps where normal workers would be fine. Also, other issues are going to be state and federal wage and hour rules, employment tax issues, potential liability for employee benefits, and worker comp concerns. A number of years ago, 10 or 15 years ago, Microsoft got dinged. They had employees that work as independent contractors for years. They sued. They wanted, of course, because they worked for Microsoft, they weren't getting any employee benefits, including any stock options, anything. They sued, and they won a case 10 or 15 years ago against Microsoft. So again, this is a real concern. Both in a way, I think an employer is going to be found in this situation is if you have employees that go to the IRS or DOL and complain, or again, the IRS or DOL analyzes tax returns and notices on the corporate return, or notice a lot of filing of the 1099s, that could be a concern. The other issues involved are overtime liability, meal and break liability, especially under state law, because there's supposed to be so many breaks for a period of time working. And again, those rules only apply to employees, not to independent contractors. Compounded penalties, wage statements, failure to pay wages when due. And there could be joint and several liability for agency workers. So again, all this is going to be compounded. One of the governmental agencies does finally audit you. Employment tax concerns in this situation: standard taxes apply plus penalties for late payment, federal and state income tax withholding liability. And again, and this has happened time and time again, if you're audited by one of the governmental agencies, either IRS or DOL, then they will refer you to other agencies for future audits. So it's just compounded over time, the various audits, and the waste of time you're going to have when these various state and federal agencies are referred for action for other governmental agencies. Some recent cases, this is the case I refer to, the Microsoft case, potential defined benefit and defined contribution, and it should be defined contribution eligibility on a retroactive basis. And again, when you misrepresent workers, there could be havoc in regard to the administration of your 401k plan or your medical plans. Can create plan operation violations because these individuals should have been offered coverage, should have been offered, so all your non-discrimination testing is all incorrect. Affordable Care Act excise taxes especially, the big penalty is $2,000 now if you don't offer coverage to 95% of your employees, and a close doesn't count. You have to offer coverage to 95% of your employees. So that's a big concern, especially if you're hiring a lot of contractors and agency workers that later became your employees, and now you thought you covered everybody. Now you're at 93%, and all of a sudden you have liability for the ACA penalty. So it could really upend your operation. In regard to workers' comp insurance, it could be retroactive premium liability, failure to provide coverage penalties, and potential exposure for uninsured losses, especially if individuals, independent contractors who are later found to be your employees are injured on the job and they weren't covered by workers' comp, the employer is going to be liable. So that's one of your concerns too. Also, protecting intellectual property, especially you have to be very careful who you hire in regard to confidentiality agreements. If you hire independent contractors especially, you have to have something in your agreement with them, the fact that that any trade secrets are protected. Of course, that's assured when you're an employee, but it's likely, and if you don't say anything in your engagement letter, there's no protection. Limit contingent worker exposure to trade secrets. And again, you have, in a consulting agreement, you have to be very careful exactly what limitations you put on there. Contractually determine ownership of any intellectual property, especially if you have independent contractors that are doing projects for you. You have to make sure you're protected in any agreements you have with these independent contractors. So again, it's less likelihood there is an issue when they're an employee, but when they're a contingent worker, a temporary worker, or independent contractor, you have to make sure in your engagement with them, intellectual property is going to be protected. Other potential liability issues, harassment and discrimination claims, especially if that individual is later found to be an employee and they're guilty of particular actions with other employees or individuals that are customers. So you have to be very careful in that regard. Tort liability for third parties, especially if they're working on site. Privacy concerns, considerations in regard to injuries or other information, and also you have to be careful if somebody works in your location, any type of immigration compliance. Whoever you hire, you have to, and again, it's less likely there's going to be substantial background checks for independent contractors. So you have to be very careful in who you hire for special projects. You have to make sure if you're using a temp agency, they do the background checks. If you hire somebody independently, you have to do the background checks too, especially for special projects. And we're talking about contractors for doing any type of work for you. You have to be very, very careful. International concern, especially if you're starting doing business overseas, common factors, and you have to look at each country you're doing business in, and what factor they're going to be using to determine employment status in other countries. All that has to be checked. Different countries have unique requirements governing contingent workers that the companies must comply with and protect against potential liabilities. An issue often arises when a disgruntled former contractor challenges his or her employment status. So all that has to be looked into before you enter in the country, and exactly how do the rules different than rules in the IRS. Amanda, do we have any comments or questions?
Let me take a look. Nope, no others at the moment.
Okay. So in regard to any type of relationship you have with an individual, especially if you're going to hire someone on a contract or temporary basis, these are all areas that you want to make sure that when you engage someone other than an employee, you have to be very careful that you cover. Any type of indemnity provisions, what happens if they're performing work for you and there's an illness or injury? I-9 compliance. How many times, if you have a contractor on site, you actually ask for I-9 compliance? Do they have the proper insurance? Liability insurance in that regard. Also, if they are working with your employees, do you have any protections in your agreement about intellectual property, especially if they can see things at your location that you want protected? And you have to be very careful in your agreements. You identify the relationship you have with that individual or that firm that you are using for services. Very clearly indicate between the parties what the understanding is. Also, you have to protect your information, especially if they're off-site, especially if they're using a computer. Do they have the proper security, especially if you're sending emails back and forth, and especially if that email contains sensitive information? Do they have encryption technology? Extremely important. If you have federal contracts, do they comply with the federal contract status, and what are the special rules in regard to that? And lastly, very rarely do employers do any kind of background checks on independent contractors or firms doing work for them. So you have to make sure that all these areas are going to be protected when you're hiring someone. So key takeaways: you have to review your policies for complying with the U.S. and applicable foreign jurisdictions. Audit contingent workforce population, ensure proper classification, especially if you're hiring temporary workers and they work for you for 4, 5, 6 months, and you may want to ask the agency or your HR department to rotate people out after a particular period of time. Audit independent contractors. How much control does your department heads have over these independent contractors, and what type of work are these independent contractors doing? If they're doing work that's similar to other employees, you have to look at the relationship and see exactly if that independent contractor is could be considered one of your employees. If there's a doubt, error in classifying that worker as your employee, because as you can see from previous slides, there could be possible liability. So what if your business has an individual who's identified as an independent contractor, but he or she has been working for your company for 2.5 years with no other clients? In that situation, there could be some liability, and that individual should be considered an employee. The same individual from the example above, but now it turns out that he or she is on the payroll for a temporary agency. Still, there's a concern there, because remember, that individual has to be temporary. And working there for 2.5 years, even with a temp agency, it's concerns that individual, depending on the type of work they do, could be considered, even though they're working for an agency, they could be considered to be your employee. An individual who is identified as independent contractor has been with your company for a year with 3 other clients. Your company represents 70 to 75% of her income, and she maintains an office in your facility, works closely with company employees, including a company employee supervisor who is responsible for the overall project. And that situation, danger signs there, because that person could be identified as your employee because there's significant economic interest working for you. They have an office in your building. They're 1 or 2 steps just away from being an employee. I think that relationship has to change. Because I think the IRS and DOL will see that individual as actually your employee. A college-age child of a company employee has been interning with your company for 8 weeks over the summer. You just have to make sure you look at the relationship to make sure it's an educational experience, and all the other rules we just indicated previously are met. And you have to look and see what type of, if that person is actually doing actual work. You have to look at that and see that if that person should be paid. Now, let's look at some do's and don'ts. Do screen potential workers and relationships for a strong inertia of independent contractor status. You have to look and see exactly what that person's doing. Don't compensate on a salary, weekly or monthly rate. Project-based rates are preferable, because the more you compensate somebody on a weekly or monthly basis, they're going to be seen as an employee. Don't provide the worker with tools, equipment, supplies, office space, full access to your computer systems, your employee handbook, or training. In that situation, those steps will move that person to be an employee. Don't contract for services already being performed by the company employees. I think the only exception to that, if you do it through a temporary agency on a temporary basis for a few months, I think you're probably much safer in that regard. Don't require the contract to work establish hours, attend employee meetings or events, or provide reports usually prepared by employees. Do focus on the final result. Do allow a worker to do subcontract work. The more you control how that work is done, as opposed to the final project, that individual will be seen as your employee. Don't exercise control over the who, how, and where and when the aspects of work. Do manage the relationship with an eye towards compliance with all the other rules. Don't retain contractors for a long term. And the exception for that is if that individual is working for other clients, depending on how much time that person per week spends with you. The more clients they have, even on a long-term basis, the more that individual will be seen as an independent contractor. But if they're just working for you and they're working for a period of 6 months or more, I think that individual will be seen as an employee. Do not use terminology or documentation associated with employment. Do have a written contract term, especially disavowing any employment relationship and any right to control, including the appropriate indemnity provision. And do protect against the pitfalls of inadvertent misclassification. And how your independent contractors do work, when they do it, should be reviewed on a regular basis. Each department head should be aware of the fact what the rules are, and especially if they're going to hire somebody on a temporary basis, make sure that it is a temporary basis and have a rule of the fact that no independent contractor, if they're working for you, should be there for a period of longer than 6 months, especially if they work many hours per week. Are there any questions?
Here we go. Does a document signed by the independent contractor stating that they understand and agree that they are not a W-2 employee have any value?
Yes, it does have value because it's the agreement between the parties, but again, the agencies will look much deeper than that and look in fact at the actual relationship and how much control as an employer you have over that individual. So statements are good because it's understanding between the party. It helps, but it's not the only factor that the agencies look at.
Mm-hmm.
Anything else?
Nothing else here. If anyone else has any questions, please leave them below. Otherwise, thank you so much for joining us. We'll see you again in 2 weeks, again at 1 p.m. Central Time, and we'll be discussing controlled group attributions.
All right, take care.
Thank you guys so much.
Bye-bye.